here today at the Global IFA Traveling Lecturers Program 2024. My name is Angela Arkusumaningtyas. I'm a Senior Vice President of Cbank Indonesia, and it's really my honor to be a Master of Ceremony of the Global IFA Traveling Lectureship Program 2024. Ladies and gentlemen, thank you so much for the participating at this event. And we appreciate that you are taking your time at your very busy schedule to join us today. I'm delighted to welcome you all to Global IFA Traveling Lectureship Program 2024. IFA, or the International Fiscal Association, is the only non-governmental and non-sectoral international organization dealing with fiscal matters. IFA is a neutral and independent non-lobby organization, and as such, the only global network in its kind. If you like to get more information about IFA or would like to join and become IFA member, please contact Ms. Indah or visit to IFA website at ifa.nl. On behalf of the host, I'm Angela, extending appreciation and special thanks to our global sponsor, Barilla, the Italian food company since 1877, and regional sponsor Generali. Right now, we are also pleased to very warm welcome to Mr. Iwan Sukardi, Managing Partner of RSM Indonesia, and also the President of IFA Indonesia, Mr. Porus Kalka, Honorary President IFA, Senior Advocate from India, and Barrister England and Wales. And Mr. Robert Dannon Partner, Chairman of IFA PSC. Mr. Makar Satria Utama, Director of International Taxation, the Directorate General of Taxes, Ministry of Finance of Indonesia. Mr. Patrick Connolly, Jebel Inc., Tax Director, Asia and Europe, the Middle East and Africa, Asia Chapter President's Tax Executive Institute. And also Mr. Permana Adisaputra, Managing Partner of PB Taxon. So ladies and gentlemen, to open the ceremony, we will now start with a special opening words from Mr. Iwan Sukardi, IFA Indonesia President and RSM Indonesia Managing Partner, Head of Tax. So without further ado, please give a big applause to Mr. Iwan Sukardi.
Thank you, Angela. Thank you for allocating your time to come to this event, Mr. Mekar Satria Utama, Mr. Porus Kaka, Robert Danon, Patrick Connolly, Pak Permana, and also all Indonesia IFA branch members and executive committee, all participant and invitation. Very good afternoon. It is great that we are selected as one of the countries to host this IFA global lecture event. I think we discussed with Horus just now that only 2 Asian countries selected, Indonesia, and next tomorrow you are having the same session in Singapore, so we are lucky. So the aim of this event is basically to socialize or to connect with the main event theme of this coming IFA Global Congress, which is held in Cape Town this year in late October 2024. And the topic is the practical, one of the topic, I think there are two branch reports that will be discussed. One of them is practical approach to international tax dispute prevention and resolution. So by having this event, basically, then we'll connect what happens in the relevant countries, and that's part of the material that will be discussed in Cape Town this year. We're lucky this afternoon we have also Porus Kaka, our former IFA president, and it's very distinguished scholars and also academics, and he will cover also these issues to explore possible improvement to the OECD commentary article 25, and then also will follow by Pak Mekar, comments from the Indonesian side, Pak Permana and Patrick Connolly. And the discussion will be chaired by my colleague Robert Danon. So unfortunately he cannot make it. So suppose Robert, you should be sit here together with Porus. Yeah, just to share with you that we've been discussing these events since basically last year, and there has been some dynamic discussion to postpone this event or to even cancel, but later on we insist that we should have this one in Jakarta. The IFA Indonesia itself, for those of you who haven't registered yet as a members, so it is, I think you may need to check the IFA global website, IFA.nl. So everything is there, the information. And we have a regular IFA annual Congress. This year it would be in Cape Town, and follow the following years in Lisbon, and then after Lisbon we'll have in I think in Melbourne and Singapore. So we as best as possible to also accommodate every region to host, and will also, if possible, to nominate Jakarta or Bali to host this event in the coming years. We need your support. That's the IFA Global. So, and IFA region Asia Pacific, it is also the good event, good venue for us to discuss if at the global level is too wide and too general, then we'll normally also discuss the regional issues, and that will be discussed in the IFA Asia Pacific. So last month we had the one Asia Pacific in Hong Kong, and next year it would be in Kuala Lumpur, and then the following years it would be in Tokyo, and then 2027 it will be in Indonesia. So one of the benefit being members is if you have to pay to seminar access, and then you will get a specific rate. In addition to, there are also a lot of materials in the website you can access from all publication, all articles, PowerPoint slides that consider maybe as one of the heritage, because it's been well documented since probably since early 70s. For IFA, so IFA Global, IFA Asia Pacific, and for IFA Indonesia itself, we have regular IFA seminar every early December. So and for many years, we've been organizing this event for only a day, so it is morning to evening. But then there has been some discussion to make it to 2 days, because I think a lot of issues that we need to cover. But for this purpose, we need to get support from the IFA members. As mentioned, thanks for the support so far, but especially to IFA Global, because this is not IFA Indonesia event merely, because it is financially supported by IFA Global. And also, as mentioned by Angela, thanks to Barilla and Generally to basically support this event. I think that's all from our side, and we'll pass this to Angela back. And please enjoy this evening, and we'll have later on also interactive discussion after some panelists present their view, and also we'll have cocktail parties and followed by the dinner. Thank you.
All right, thank you so much, Mr. Iwan Zukardi, for the opening remarks. So before we move to the next session, please be informed that during these sessions, feel free to write down any question or answers and give it to Miss Debbie, the one that's standing right there. Hi, Miss Debbie, or me. So feel free, and then we will pass it to the Mr. Porus Kaka for the panelists to answer the question or give any feedback. Okay, now we would like to move into the next sessions. There will be opening remarks on the scientific program. But before we start this section, please let me present the CV of Prof. Robert Dannon. Prof. Robert Dannon is a Dannon partner, chairman of IFA PSC, chairman of the Permanent Scientific Committee PSC of IFA. Robert Dannon is full professor of law at the University of Lausanne, Switzerland, where he heads its tax policy center and leads its research platform dedicated to tax dispute and investment arbitrations. Next, his academic duties. Professor Dannon is a founder of Dannon, an independent firm, international level. His academic and practical expertise focus on the international tax dispute, with emphasis on the tax treaty and their interpretations, not discriminations, abuse of rights by the taxpayers and states, comparative taxations and transfer pricing. He also concentrates on the interaction between investment arbitrations and tax-related dispute. So without further ado, so please give the big applause to Mr. Dannon.
Well, good afternoon to you all. And first of all, apologies not to be able to join you in person. I hope I will have the chance to visit Indonesia in the near future, and also to interact with the IFA friends. Let me give you, perhaps without taking too much time, because I think the core is really the presentation of my dear friend Porus Kaka, but let me give you perhaps some opening remarks on the scientific program, and perhaps more broadly what this traveling lecture seeks to achieve. So next slides. Yes, so as it was previously mentioned, one of the core area of global IFA currently, scientific focus, is basically dispute prevention and resolution from a holistic perspective. This is a key priority, a main subject of the Cape Town Congress, but it will continue after the Cape Town Congress. So what IFA wishes to achieve with this traveling lectureship program is, on the one hand, to offer a global perspective on dispute prevention and resolution, with a particular emphasis on the mutual agreement procedure under double taxation treaties, with the objective of making, in the end, suggestions for improvements to the commentary on Article 25. As Boris will show also in his presentation, the OECD has done significant work in this area, leveraging also on the principle of good faith to enhance the mutual agreement procedure, and this has basically emerged in the form of minimum standards. Now, there are still controversial issues in practice, and what this global traveling lectureship program wishes to achieve is basically to see the areas of the commentaries that may be improved, whether it relates to the access to the mutual agreement procedure or the operation of the mutual agreement procedure itself. And from that perspective, we think at Global IFA that interaction with the local branches is, of course, of significant importance. So we've been, if I may use that term, traveling the world so far, starting from Paris, the UK, Canada, the US, Latin America, and of course now we are very pleased to come to Indonesia. So your inputs also from the panel, but also presumably from the floor, will be of extreme importance in this regard. Next slide. And just to mention that core focus of this traveling lectureship program is really on the mutual agreement procedure, the state-to-state dispute resolution procedure. But if you come to Cape Town, you will see that we will revisit dispute resolution in a number of ways through companion seminars, also exploring broader issues and broader interaction, notably the interaction between dispute resolution on the double taxation treaties and investment treaties. One point which is for the future, I would say for the ongoing presence, is really how this is going to interact with the implementation of the global minimum tax. This is presumably something we will touch upon with Boris. The mutual agreement procedure, as you will see, has been shaped to solve tax treaty disputes stricto sensu. Question is, how are we going to address the Pillar 2 disputes, which is an emerging but nevertheless very important topic. So without further delay, I'm very pleased to give the floor to my dear friend Boris, who will actually give the substance of this session with his traveling lectures.
Good afternoon, Robert, my dear friend, chair of the PSC, Dr. Uttama, the Director of International Taxation in the Ministry of Finance, Mr. Satputra, the Managing Partner of PB Taxan, Mr. Jadi, the State Subdirectorate of International Tax Dispute Prevention and Settlement, Patrick Connolly, Jabil, and Tax Executive Institute. It is an honor on behalf of Global IFA to be present here in Indonesia, for me especially, for the first time. I was fascinated to learn from Dr. Uttama and my friend Sukardi that Indonesia is one of the few countries from Asia, other than Japan, to now have applied to become a member of the OECD. The world is undergoing a struggle between the West and many other powers, and that is also true for the tax world. Fortunately, in our world, we use words, not guns. I apologize for not being so colorfully dressed as all of you, but if I had known a little bit earlier, I would have used the batik shirt that I bought yesterday. With these few words, I'll get to the thrust of my presentation. And the last part, which is improvements in Article 25, I know that Robert has written an exceptional paper on that, and perhaps he will supplement that part of the discussion. So let's go back a little bit in history. First of all, Action Plan 14. What were the objectives and where are we now 9 years down from that plan? For me personally, when I read Action Plan 14, when it was released, and you must remember, OECD did that entire work in a period of 2 years and they brought in 15 action plans. This is one of the most underrated successes of BEPS because it brought dispute resolution and prevention to the forefront as a minimum standard of the BEPS program and applied it across the world. And as tax disputes were growing, this was an extremely timely plan. And within it, because a lot of people complain that, oh, this is a failure of 14 because it never came out with arbitration. But I think that's wrong. There is a lot in that minimum standard, which are great successes, especially when most of the world was not ready and is still not ready to accept arbitration. So what were the objectives originally? It was to ensure that treaty obligations related to MAP are fully implemented in good faith. Ensure MAP cases are resolved in a timely manner. Ensure that administrative processes promote both the prevention and the resolution timely of treaty disputes. One of the conditions was that that the treaties meet the requirements of paragraph 1 of the OECD. What were the elements of the minimum standard? So the first element, which is really a judicial part to be incorporated in treaties, is that they should ensure that the treaty obligations related to the procedure are fully implemented and resolved in a timely manner. What were the steps? Include paragraphs 1 to 3 of Article 25, and I'll come to what is 1 to 3. Provide MAP access even where there's a disagreement between the taxpayer and tax authority on access to MAP. Now, importantly, timely resolution of MAP within 24 months. Enhance the relationships between the competent authorities and taxpayers in the forum of tax administration. And most important and a success of Action Plan 14 is timely and reporting of MAP statistics with a peer review. Why do I say that? Because this was a mirror to countries and their taxpayers. If you all remember the story that we learned of Snow White when we grew up, it said, mirror, mirror on the wall, who's the, I will not use the word fairest, that is not correct. I think it is who's the most efficient of them all. So when these statistics are put up, the countries know how successful their administrations are in resolving the disputes and where they fall compared to their competitors in the international community. And I think this is the effective way to get the administrations to ensure that the objectives of Action Plan 14 are efficiently resolved. What were the administrative parts of this minimum standard? It was that countries should ensure that administrative processes promote the prevention and also timely resolution of treaty disputes. One of them is publish rules, guidelines, procedures to access and use MAP and take such measures to make them available to taxpayers. Sometimes this is counterproductive. I have seen in some country guidelines, when they actually publish them, they are perhaps more restrictive. But of course, since they are published and in the domain internationally and publicly, people can object, criticize, and hopefully get the countries to change them. The other, of course, is I have dealt with it, that they should clarify in their guidance about audit settlements and also certain advanced ruling procedures like the bilateral advance mechanism, advanced pricing mechanism. They should provide for a rollback. So what were the elements of a minimum standard when Action Plan 14 was introduced? As I said, they should be aware, first of all, paragraphs 1 of Article 25 should be clarified. They should publish the guidance. And most importantly, one of the other judicial part was include in their tax treaties the second paragraph of Article 25. So now all of you perhaps are a little confused as to what Article 25 is all about. So let's go to Article 25. Whenever there is a dispute and you wish to go under the mutual agreement procedure, Article 25 is your starting point. So that provides that when any person considers the actions of one or both of the contracting states to be resulting in taxation not in accordance with the provisions of the convention, he may approach, and now the change is either competent authority. Previously, you had to go to the competent authority where you were resident in. Now you can go to any. Now remember, 25(2) was to be introduced. What is 25(2)? So first, you remember 24 months was the condition imposed, not imposed, but requested for the competent authorities to settle their procedure. Suppose they do it beyond 24 months. Suppose the timelines for implementing the procedure are beyond limitation in domestic law. 25(2) comes to the rescue of all taxpayers, which is that the agreement, if it comes to, will be implemented irrespective of time limits in domestic law. And I think this is important for all taxpayers to be aware of that. The third paragraph is that the competent authorities of the state shall endeavor to resolve by mutual agreement any difficulties or doubts arising to the interpretation or application of the convention, and also work together for the elimination of double taxation. How can we expand on these words and improve on these words is something that Robert will come to later. So if we look very briefly, what were the objectives of our Action Plan 14? I've set it out, but we don't need to trouble. Now I come to where the OECD is at present. This slide is courtesy my good friend Akib Pross at the OECD. So if you will see, this bracket and these slides which have been broken up by the OECD consists of 3 categories: rule simplification, dispute prevention, and dispute resolution. So firstly, what are the existing rules? The existing rules are how to calculate amount B, advanced pricing arrangements, cooperative compliance. What is cooperative compliance? This is a domestic trust-based system which has been implemented in some countries. Risk assessment under ICAP. What is ICAP? This is the International Compliance Assurance Program that 23 countries have today signed. I do not think many countries of Asia are part of this. I'm not sure about Indonesia, but I'm sure Yuli mentioned. This enables disputes to be settled across the board within the revenue administrations, and it assures the taxpayer of certain things. The next is, of course, audits, coordinated or joint between countries. Then we come to the last. What is dispute resolution? I have already dealt with very briefly what is Article 25 of the treaty. And we will come very briefly to the options that are available on arbitration in the last part of 25. Now let's move to how are these existing and future to be dealt with. So now look at tax certainty on amount A. So what is tax certainty, there was a report jointly of the OECD and the IMF in 2017 based on the G20 mandate. Now, one of the disputes and the significant disputes that will come under the global minimum tax program is the working of Amount B. The OECD has recently published a paper, and what they call is the simplified, streamlined approach. The guarantee is if taxpayers follow that approach or adopt that approach, there will be no audit in the country where they are distributing the product. Of course, the country itself has to accept this. It's currently optional and not binding it. Then there is a scope of certainty in the multilateral convention. To the best of my knowledge, there are many reservations that countries have on the approach or a global comparable approach to Amount B. And the reasons are, when you standardize a percentage on the distribution, just to explain to you in case many of you, there is a calculation first to determine how much of your global profits for a multinational company that will fall in Pillar 1 will be distributed across the world. Then there is Amount B, which is in each country, you will get a minimum deduction for your baseline marketing and distribution costs. Now, how do you determine the transfer pricing for the marketing and distribution costs? The current working is a simplified global approach with standardized margins across countries or across sectors, if I may say so. Certain countries are not comfortable with this because A, they have a database which perhaps gives different figures, and therefore it may be not fair to the source jurisdiction. But the objective of this is to help countries that do not have such a high database, that do not want to have these high costs in determining these margins, and hence this simplified approach comes in. So what are the three ways of determining the certainty of the amount? Firstly, you can have advanced certainty on the systems that the multinational employs. You can have certainty on the scope, whether you're covered by Pillar 1 or not. And you can have comprehensive certainty when those 3 countries or 4 countries deciding how to apportion the amount of Amount A to each jurisdiction sit together. You will see a very interesting pillar or a bracket in 2 on the top of the slide, because Amount A is not isolated from treaties. There will be PE calculations. There will be other disputes that are related to Amount A, and how do you settle them? That is proposed in a unique mandatory dispute resolution method, wherein if it does not get settled within the 3 countries or the 4 countries in the comprehensive certainty, it can go to mandatory arbitration, and that arbitration will have majority independent experts. And as I was explained by the OECD, this has been accepted even by countries who are normally resistant to arbitration. I think this is a good step forward, because ultimately, I think the whole purpose, to me, I don't know about you, to me, I can read Pillar 1 today, Pillar 2 tomorrow, and not know what it means day after. It is one of the most complex systems of taxation that is going to come about. And I think any effort to streamline it, to simplify it, and more importantly, to prevent disputes or to resolve disputes are welcome from all our angles. So now, where are we on the tax certainty? If you will see, this is the forum for tax administration coming out of the G20 and the OECD mandate. There are 53 countries in this forum, those who are either members of the OECD or those who are either members of the G20. How many have implemented the minimum action plans of Action Plan 14? You will see all 53 have done it, which is why I say it is a success, one of the underrated successes of the action plans. How many have an advanced pricing arrangement program? About 83% of these countries. And I'm assuming Indonesia is a part because it's a part of the G20. Cooperative compliance, about 40%. Now you come to arbitration. And you will see that this statistic shows 72%, but this is, to extend with respect, misleading, because this consists of OECD plus G20, not OECD plus the world. So when you see 73%, you will see that significantly the members of the FTA accept arbitration because they're OECD, but a lot of the G20 and other countries do not. Then, of course, you see the other statistics of joint audits and CAP. If we now focus on MAP, you will see how this evolution has happened over the years, especially since 2016, when Action Plan 14 came in. And if you will see, there is an increase of 70% in cases open and closed. Average time for transfer pricing disputes, 24 months and decreasing. For other cases, it is below 24 months. And I find it interesting that countries can agree as to whether you have a P or not in less than 24 months, but cannot agree whether you should get 5% or 10% in that same time frame. So you will see transfer pricing takes longer. The other cases take slightly less. Few more statistics on the OECD work. And then lastly, where are we currently? So if you will see, many treaties, there is currently was no effective MAP provision prior to Action 14. More than 500 treaties now have MAP provisions to encourage dispute resolution. There was very limited rollback earlier. Now it's a common practice. There were many restrictions earlier to access MAP. Now it is granted in most of the cases. So again, this is a success. At this point, you can go to the next. At this point, I want to stop and go to the UN because much work is going on the UN. And I had the privilege of reaching out to Michael Leonard at the UN a few days ago. So as you're aware, with the push from Nigeria, the UN has now passed 2 resolutions at the General Assembly to encourage a UN tax framework and tax convention. This is perhaps for the first time that UN is coming so actively into the international tax scene. And for many developing countries, the UN is a source for material, especially when you're concerned from a source country perspective. One of the first protocols, and one of the protocols that the work is going on at the UN, is on dispute resolution. And I think, of course, it's early days, but to see all the UN countries, and Michael informed me, there is encouragement, even mainly from the African countries and some of the major developing countries, that this is an important focus. And I think that's right. If you're going to have a tax convention, that's fine, but you must have a convention also to ensure that there are no dispute resolutions. So what is the focus and where do we go from here on MAP? And I think the only answer that I can get to you is, if you really want to know where we are going, you need to be in Cape Town in October for the IFA Congress. A few slides on access to MAP disputes. I won't trouble you and denial, but since I'm a litigator, I can't run away from these slides which give you a small overview of how MAP cases have actually landed up in the courts of the world. Judicial review, much earlier. So the slide with Kevin McCabe. So few cases, and I'll try to be brief. They are in my slides. You can look at them later. In the UK, there was a case brought by Mr. McCabe. He had a dispute on whether he was a resident of Belgium or a resident of UK. Both the competent authorities agreed that he was a resident of UK, but Mr. McCabe did not accept that. He fought in the domestic courts, and one of his pleadings was, give me the access to the documents or the position papers that both the competent authorities had taken when they were negotiating, so we can see that their stand is now inconsistent in the domestic courts. The first tribunal, which is the UK's first body, decided that, okay, how do we approach this? Number one, firstly, the default principle in UK is the tax authority should disclose documents to the taxpayer unless there is a valid reason. You must remember that competent authorities keep on saying, no, these are confidential, these are intergovernment, we will not disclose them. Second thing is, if there's a document relevant to the case, it must be provided. Thirdly, where there is a valid reason to withhold, you will have to balance these considerations. And what do you balance? Is this a document of low importance or is it a document of high importance? Ultimately, the tribunal came, and this was upheld in appeal, that the position of the UK authority, which the judge had read, was not inconsistent either in MAP, and because it was not inconsistent between the stand they were taking in domestic courts, it was of low importance and should not be disclosed to the taxpayer. Exactly the opposite happened in Belgium. The Belgium court held that the MAP documents must be disclosed to the taxpayer. And you must remember today, all countries give position papers. And this is fascinating because if you can get a position paper of a government, then you know what is their stand. And obviously, the government cannot be contrary in domestic courts. Similarly, two decisions, one after another in Belgium, entitling the taxpayer to competent authority documents while negotiating treaties. Another thing, can MAP ever be judicially reviewed? The answer is again, yes. But when? For example, in the case of CGI Holding, there was a Canadian taxpayer and the two authorities failed to resolve the dispute. And the question was, can they be compelled to ensure that there was fairness? The answer is yes, but the court found on the facts of that case that there was no denial of procedural fairness. The last slide, or the second last slide, is what is the binding effect of MAP? You always think MAP is binding, it has to bind. But interestingly, in Canada, in the case of SIFTO, the Canadian Minister of Revenue said we will not apply it, even though they had agreed with USA on certain reasons. And the reasons was, my competent authority agreement with USA, this was a transfer pricing dispute, was on TNMM, but not on a price. And because that is slightly different, it's not binding on me. The Canadian court said nothing doing. The method, the letters, the settlement disclosed what you have agreed. That agreement is binding on the minister. It has to be implemented. Lastly, an interesting line of cases that I had the privilege, of course, these are public cases. In the case of JP Morgan in India, what is the effect of MAP outside MAP? So very interestingly, JP Morgan had an entity in India that rendered services to various entities of JP Morgan across the globe. 95% of that entity's transactions were with JP Morgan US, but 5 were with JP Morgan UK and other countries. India and US had a settlement on what should be the margin for the transactions between India and US. That left 5% dispute in our open courts, in our domestic court. And the question was, how do we settle that 5%? And the argument was, obviously, transfer pricing is a very scientific thing. You have to do the functions, assets, and risk analysis, which is called the FAR analysis. It's not that you take one margin and apply it there automatically. But the argument that we gave the court was that there is no difference pointed out by the revenue between the work JP Morgan India does for US or JP Morgan does for UK. If there is admittedly no difference pointed out, no difference even argued, Surely reasonable requires that margin cannot be different. So whether you work for a UK or a US, it can't be different. This was accepted by the tribunal. But when I came to the High Court said, no. How can you have this situation where you have one competent authority agreement applied to countries which are not even part of that agreement? Fortunately, by the time we came to the High Court, India had an advanced pricing agreement with JP Morgan for the subsequent years, wherein they applied the same margin not only to US, but to other entities. When the High Court saw that and realized that in the past, this is done, in the future, this is done, for that current year, you can't have a standard which is different, and accepted it, and the Indian Supreme Court has thrown out. What is the answer? I think the answer in all transfer pricing disputes is reasonableness. Transfer pricing does not mean you have to earn the maximum profit. It is to ensure that it's an arm's length profit or a standard of reasonableness. So these are some of the judicial effects of MAP, both within and outside in the litigation sphere. Very briefly, I will skip arbitration in the interest of time. And then I will skip, I'm sorry, I'm supposed to be here tomorrow. So let's come to Indonesia to conclude on. And these are again slides courtesy the OECD. In Indonesia, now 70, and of course, I'm subject to correction on this, 70 out of 72 tax treaties contain a MAP provision in line with Action Plan 14. What is your structure of the competent authority? All of you know what it is. And finally, on some statistics, this is the mirror. This is the mirror that all countries put out for the rest of the world, whether it's in Indonesia, it's in Singapore, it's in India or the US. These are the statistics that are available at the OECD. You have closed 10 MAP cases. The time to resolve is about 44 months, so it's perhaps slightly higher than what the OECD expects. Indonesia did not deny any MAP access to any taxpayer. 1 was withdrawn to 4 no agreements, 5 with full agreement. So this is very briefly where we are, both in dispute prevention and dispute resolution. What are the ways we can improve Action 25? And here I will briefly hand over back to Robert for some comments before we conclude this.
Yes, thank you very much, Boris. Not to make it too long, I think I entirely agree with you that BEPS Action 14 was the best compromise, given the fact that there was not much appetite for a wide application of tax treaty arbitration. So what the OECD did is basically to streamline, as you pointed out, the MAP process with minimum standards. And this has significantly improved the dispute resolution landscape. Nonetheless, when we look at the current OECD commentaries, there are still open areas which leave a certain degree of uncertainty in practice vis-a-vis the current landscape. So let me give you perhaps some of the examples that I see in my practice, but that have also emerged in previous traveling lectures. We see a tendency in terms of access to MAP of cases in which there is a recharacterization of what should be a tax treaty dispute in a domestic dispute, whether through an overriding provision, whether through a GAR, and this basically blocks the access to the MAP. Another area of tension is audit settlements that were actually mentioned by Boris. You still currently have a number of states that will tell you, well, you need to settle when we actually want you to settle, otherwise you're facing probably some criminal law ramification. But when you settled, then of course we're not prepared to revisit the outcome in the framework of a bilateral MAP. And that, of course, runs a bit at tension with the current language of the OECD commentaries and affects the map. And then there is, of course, the future, to which Boris alluded to, and that is basically the global minimum tax disputes. There, indeed, I've written on that with other colleagues. The problem that you have is that the map is essentially confined generally to tax treaty disputes, to disputes that are rooted in tax treaty law. The problem that you have with the global minimum tax, it is basically domestic law, the implementation of a common approach in domestic law. So it does not really fit into the MAP process. The only connection with the MAP process is Article 25.3, which basically gives the competent authorities the possibility to settle disputes that are not covered by the convention, but this is just a consultation and a very light procedure. But on the other hand, what we're seeing now through the implementation of the global minimum tax is that disputes will arise, whether they concern the divergence between globe legislation, whether they concern divergence with the administrative guidance, disputes will indeed arise, and therefore a framework is necessary. This is why, further to this study that we have produced, basically two options are currently on the table. One would be a reciprocal domestic dispute resolution that would be activated to solve globe disputes. And another one would be the idea of a mini multilateral convention in which you would have an ad hoc dispute resolution process. So what this actually means effectively is that the notion of international tax is, and the notion of international tax disputes is much wider than the scope of the MAP. And the most prominent example of this mismatch, if I may use that term, is the global minimum tax, which is clearly international tax. No one would dispute that it is not international tax, and yet it doesn't really fall into the only available dispute resolution mechanism. So this is basically one of the tension that will need to be addressed. So these were my thoughts on your questions, Boris.
Thank you, Robert. So I think today, after seeing Action Plan 14 and after so much work, we have expanded MAP, we have expanded access to MAP, we have expanded timelines when it's being solved. One of the solutions that Robert is proposing, or at least has suggested, and as he mentioned, the discussion, is to expand MAP even beyond the treaty network to perhaps global minimum tax domestic solutions. All I can say is good luck. So now to the end, there is much work going on at the OECD and at the UN on dispute resolution and prevention. I can see many scared faces in the audience, especially from the professionals, that if they are creating so much work on dispute resolution and prevention, what will happen to our careers? Don't worry. As they settle, they are creating multiple opportunities for you. Pillar 1, Pillar 2, STTR, new UN convention. So I can guarantee every single government official here, lawyer, chartered accountant, it's going to be a world of work. For the taxpayer, it's a tough world about to get much tougher. Thank you.
Thank you. Thank you very much, Boris. I think that, well, it's always more difficult to do that when you're not present in person, but it's now, I think, the time to open the panel discussion, and we have agreed on the number of structured inputs to follow up on what Boris has said. And therefore, I would welcome the remarks of Dr. Meka Satra Utama, who is the Director of International Taxation, for a perhaps deep dive into the Indonesian landscape.
Sorry. Okay, thank you for the time. Let me address the important people here. To Mr. Robert Donald, thank you very much for your time and also comment regarding what Indonesia are going to present next. Mr. Porus Kaka, thank you for your very good explanations. And Mr. Patrick Connelly, Pak Iwan, and also Mr. Permana later on. To Mr. Porus Kaka, thank you for delivering many crucial takeaway. I've noted some key points that we will need to explore further on. I particularly appreciate your breakdowns of the objective behind BEPS Action 14 and the roles of global standard in dispute resolutions. Taxpayers now have more options to pursue tax certainty. Through your presentation, we gain a clear understanding of the scope of mutual agreement procedures and issue of access or denial MAP requests. Also, your explanation, your example of the judicial review in relation to denial of access to MAP and your mentioned access were very helpful. In my recollections, we don't have those kind of issue yet regarding opening informations regarding MAP or APA, but that is very important issue actually regarding data safeguard and data confidentiality, because in one of my panel before, I heard that many of taxpayers kind of reluctant to go to the APA, for example, because they are worried that the data is going to be used by the tax authority to other processes, for instance, for audit process. But that is not the issue right now for Indonesia. In today's discussions, I would like to share some exciting advancement and ongoing initiative we have in dispute resolution area. So next slide, please. Basically, we are adopting those MAP and APA based on the OECD minimum standard. So we can see here in Indonesia, if taxpayers having problems, have issue regarding transfer pricing or other tax related dispute, we understand that they have two options for resolutions, which is a domestic remedy. I believe that many of you here understand objections appeal, judicial review, or also the international issue through mutual agreement procedures. These options depends on their goals. Domestic remedies is aimed for a definitive outcome, like full acceptance, partial acceptance, or rejections of the taxpayer positions. But the MAP, however, focus on minimizing double taxation by reaching a mutual agreement between countries, shifting the focus from winning or losing to finding a collaborative solution. So for MAP, our goal actually how to divide the taxing right between jurisdiction to minimize double taxations. To help taxpayer further mitigate transfer pricing dispute risk, we have also APA. Our latest regulations introduce now in our regulations, we introduce what we call multilateral APAs. That is our aim to provide greater tax certainty for our taxpayer. We have a unilateral APA, involves negotiation solely between the taxpayer and their tax authority. Bilateral and multilateral APA, on the other hand, involve negotiations between the taxpayer, tax authority, and the authorities of their relevant partner countries. So this is, I think, quite understandable by many of audience here regarding the system that we have in Indonesia. Next slide, I'm going to mention our new regulations regarding issues of MAP and APA. We had what we call Indonesia Transfer Pricing Guideline, which is regulated in Ministry of Finance Regulation number 172, 2023. In these regulations, we consolidated all transfer pricing related issues including mutual agreement procedures and advanced pricing agreement. We have chapter 7 and chapter 8 that in the MAP chapter, we discuss regarding the scope of MAP, how to access the MAP process, procedures for processing MAP requests, interaction between the MAP process and domestic remedies that I just mentioned earlier, and also implementations of MAP outcomes. While on the chapter 8 regarding APA, our regulations is discussing about the subjects eligible for APA, transaction covered by APAs, application process, procedure for negotiating and finalizing, and also the implementations of the APA outcomes that have been concluded between each party. Now, regarding the mutual agreement procedure, in our new regulation, we encourage fairness and legitimacy. Previously, the interactions between MAP and domestic remedy lacks flexibility. For instance, if a tax assessment letter went to court and tax court decision has been made, taxpayer had to withdraw their MAP requests. That is before our new law, Harmonization of Tax Law, number 7, 2021. To ensure fairness in our new regulation, we allow taxpayer to pursue both MAP and domestic remedies concurrently, as long as the MAP dispute concern matters is not already addressed in the court decision. This is really happening, colleagues, because many of our previous MAP discussion is being withdrawn by taxpayers because the assessment already been decided by the tax court. Now we give more flexibility. If the court decision it is not discussing about the issues of the MAP, then MAP can be continued to discuss and we can have conclusions regarding those issues. Then for enhanced legitimacy, the previous requirement to follow up on MAP with domestic remedies, it's also have been removed. This eliminates several drawbacks. Now, our finalized MAP is follow the issuance of the mutual decree, which serve as the sole basis for tax refund or collections independence of domestic procedures. This is actually our internal processes before the MAP decree cannot be used directly to give refund or collection if there is some assessment that need to be collected after MAP. Now, after the agreements been achieved, we issue what we call mutual agreement decree that can be served as assessment later, and it can be used to give a refund directly or collections if needs to. So these new regulations also establish a legal basis for adjusting administrative sanctions within the tax collection letter, considering the amount of tax specified in the mutual agreement procedure decree. This is also another simplification and fairness that we introduced to taxpayer in our new regulations, that before it is not also mentioned the sanctions, it is not mentions in the decree. Now the decree also mentioning about the sanctions, so all of the issues can be solved immediately and all together issue will be discussed. We have our statistic. Mr. Porus Kaka mentioning 2022. This is our statistic until April 2024. So from 2016 to the first quarter of 2024, we received 231 MAP applications. The successful completion rates is 80%. The breakdown is 43 applications reached agreement that fully eliminate double taxation. 26 applications result in agreement that partially eliminated double taxation. 2 applications confirmed there was no taxation that violated the tax treaty. 47 applications did not reach an agreement, including agreement to disagree, and 2 applications deemed unjustified. We have other outcomes. 14 applications were resolved through domestic remedies. 3 applications received unilateral relief. 11 applications were withdrawn by taxpayer. And we have 34 applications reached any other outcomes. 3 applications were denied by DGT due to taxpayer missing the application's deadline. Transfer pricing issue dominated the MAP case, with a small number related to certificate of domicile and withholding tax issue. The average times to complete an MAP process is 31.78 months, little bit lower than 44, although still higher than 24. The challenge for us is because sometimes it is difficult to have the meeting, competent authority meeting with other jurisdictions, usually only 1, maximum 3 times annually. Now, because of the COVID, we have what we call Zoom meeting, MS Team. It is more easier for us also. Before we have to go or they have to come to Indonesia to discuss MAP cases. Now we can use technology to discuss issue, although we still have some restrictions regarding how we manage the data and information. So that is the statistic for MAP. Although we have actually our domestic regulations that give the time to discuss of the MAP process to 24 months and can be extended for another 24 months. This is our way actually to, what is it called, to push other jurisdictions that we are mentioning that we have only 24 months to discuss this issue. If we cannot reach at least some part of the agreement, then by our domestic law, we have to close the negotiations. This regulation is being challenged by many jurisdictions actually, but that is our way, at least for internally, to make sure that we are achieving 24 months minimum standard to resolve MAP cases. Next, for the APA, we have new regulations that promote for multilateral APA, and we have some incentive also. We remove administrative sanctions for implementing an APA. Sorry. We hope this will encourage more taxpayers to apply APAs. This is actually something that we discuss if we have a rollback regarding our APA. Sometimes when we agree with the APA and the rollback period is will make taxpayer have to make another payment just to in accordance with the APA agreement, then they have to pay additional tax. This additional tax usually will create a sanctions of the late payment. Now with our new regulation, it can be the sanction can be removed or can be agree with our domestic regulation. So this is something that hopefully can encourage our taxpayer to do the APA more often. The statistic is like this. We have see here between 2016 and the first quarter of 2024, we have received 149 APA applications. 99 of those applications already concluded successfully. Of those 99, 44 applications reached an agreement, 8 were formally rejected. 28 applications failed to reach an agreement, and the remaining 18 were withdrawn by taxpayer. Approximately 68% of the APA applications were for bilateral APA, as they provide more certainty for Indonesian taxpayer and their foreign counterpart. The average times, this one is higher than the MAP, which is 34.9 months to conclude. Our partner, the biggest issue that we have for the APA is Japan, South Korea, Singapore, Switzerland, Thailand, and Netherlands. While for the MAP, mostly our cases regarding with the Netherlands. Next, a little bit regarding the capacity building. This is the issue that we are doing right now. Yes, we are still having problems regarding how to increase capacity of our auditor, our objection and appeal, and also our account representative. This is the way that we do. We have the internal workshop. We have joined the GT OECD capacity building. We have the internal capacity building with the Education and Training Agency, Ministry of Finance, and also we have doing the training program, International Certification Training Program. This is the issue that already been addressed by us, and hopefully by gradually we will improve the capacity of our auditor, account representative, and also our objection and appeal process. A little bit issue regarding Pillar 2 timeline. Basically, for Pillar 2, we are now drafting the regulations, Ministry of Finance regulations. For laws, for the tax law, it's already been implemented. It's already been mentioned in our harmonization of tax law, law number 7, 2021. We also have the government regulations. Now we are drafting the Ministry of Finance regulations. We are going to touch some issue regarding the domestic law, QDMTT, and also how it impact with our tax in the future. Regarding that, this is this issue. So the slide about tax certainty from Mr. Paulus Kaka. I see that you have, Mr. Robert also mentioned that there are 3 options presented. Well, this is still something that being discussed in the steering group in inclusive framework. We don't know what is the best solution regarding this, but we believe the ideal one is if there is issue regarding Pillar 2, which is domestic law, it is not included in the treaty, although we can use Article 25, Para 3. But if we can resolve this issue for global minimum tax through MAP, it would be best and should be also changing in our MLC later on. Interpretation of Article 25, Para 3 also mentioned by Robert, but we have issue regarding MAP for the global minimum tax because we don't have our legal framework to cover those issues. So basically still being discussed, Pak Porus Kaka, but if we can discuss this, if we can solve the issue through the MAP, we change some in the MLC and our treaty, then it would be better regarding the how to administer this in the future for us. Some other issue that you are mentioned regarding Pillar 2, I just say that we are already drafting the regulations, and yes, we are also waiting for the how are we going to have the dispute resolution or preventions regarding this issue. For Pillar 1, there is discussions, and yes, Indonesia also one of the country that agree with the arbitrations. India also agree. the part that we are not really agree with the abbreviation regarding how to handle issue of the pillar 1 is how who is going to represent its jurisdictions. It's already mentioned that some of the practitioner can be appointed as the representative of other jurisdictions, but there is some issues regarding how are we going to pay for the practitioners for that. I think there is some issue that I would like to address regarding Indonesia. If I can recap that, yes, we are moving, we are in accordance with the OECD guideline, BEP Action 14. We are also now already established, implement our new regulation that hopefully can give more flexibility, more certainty for our taxpayers regarding dispute resolution and also preventions of the treaty or transfer pricing issue. Thank you.
Thank you very much, Dr. Meta Saya Utama. Perhaps if I may follow up, I think it's a very interesting the presentation you gave, because it shows how active Indonesia is in implementing the framework of BEPS Action 14. I also very much agree with you, the comments you made on Pillar 2. Ideally, we would want to have a mini multilateral convention with a dispute resolution framework that would allow, indeed, Pillar 2 to be solved through the MAP process. Perhaps just one question, if I may ask you, on the implementation of the Pillar 2 legislation in Indonesia. One question that I see emerging in other jurisdictions is basically, on the one hand, we have the GLOBE model rules, and on the other hand, we have now successive, of course, administrative guidance that is being issued by the OECD, the latest one being in December. Jurisdictions have taken very different options in dealing with subsequent administrative guidance. Some of them basically decided to codify the administrative guidance in the law. Others have interpretative provisions, basically stipulating that the rules will be interpreted in accordance with subsequent guidance. What is the approach taken by Indonesia with this dynamic, if I may say, evolving framework?
Thank you, Mr. Robert, for your questions. We are playing a safe side. So in our regulations, we will add if there is some new changes in the previous regulations. But right now, we are still drafting based on the latest guidance and also commentary and regarding the global minimum tax regarding Pillar 2. It's quite, in our opinion right now, it's quite robust that can be used, but actually we have issue regarding the incentive. There is more pressing concern for us regarding how are we going to change the incentive that we are going to give. What happened with the already signed concession, and what is a more attractive incentive that we are giving to our new FDI to Indonesia. But on your questions, we are doing the safe side. We are using the current commentary and guidance that we have right now, but we are open to some adjustment later on if it really impact the baseline that we have or base regulations that we have on our tax law right now.
Thank you very much for this. I'd now like to give the floor for an input by Patrick Connelly, who is the TEI Asia president, and basically, Patrick, the question that we would want to have you address mainly is, how do you see the dispute resolution framework within Asia from a business perspective?
Okay, thank you, Robert, and Professor Otama, and Dr. Otama, sorry, and also thank you for the fellow IFA executives for the invitation, and apologies I cannot be there today, but unfortunately traveling with my work job this week. So look, it's a good opportunity. These are my personal comments, and I always welcome dialogue with professional bodies and tax administrators, and I think that's a positive thing. I think with the MAP process, the broad framework, I think everyone should be very familiar with, but there's some key framework principles in there that I think are very important to re-emphasize, and are certainly important to taxpayers. And that is, I think, obviously both parties are going in good faith, and that I think underpins certainly the whole MAP process. And there's comfort there. We know that jurisdictions and government authorities, they've themselves committed to standards that will be reviewed by their peers. So that's a good thing. There's transparency, and there's also an undertaking by the tax authorities to be adequately resourced. In addition to that, the MAP staff are required to have the delegated authority to rule and to opine, and there are no revenue targets set. So all those broad sort of frameworks are a very a positive way to set up discussions. For taxpayers, I see MAPs a bit like going to the hospital. You prefer not to go to a hospital, but if you do, and you need it, I guess you're pleased that it's there. So I think it's a bit of a comparison there, but I think it's a sort of a reasonable one. There's a couple of key aspects, I guess, from my perspective, and of course these are personal observations. The one is that from a taxpayer's perspective, one of the key points of an MAP process, of course, is in Article 25. It specifically refers to where you have it results or it will result in double taxation. So that allows the taxpayer, of course, to I guess enter into a prevention type application as well as a resolution stage. So that's a positive thing. And as I said before, the key thing is going in is good faith, and I think taxpayers generally, we would go in good faith of course, for a number of reasons, and very similar reasons as to the parties on the other side. For taxpayers, of course, there's the risk of reputational damage if there is a large correction that becomes public through the accounts. Certainly within corporates, exactly like tax authorities, there are serious resource constraints now, and I think that's a real challenge for administrators as well as corporates in the tax field now, just with the complexity, the development of technology, all these things. So there is definitely a resource constraint on taxpayers, and that would make us pause before we would enter into an MAP process. So you've got resource constraints, and then just from a purely selfish perspective, from an in-house perspective, you have your own internal performance measurement. And as a general comment, any MAP process, of course, is going to have internal profile. You'll always, without doubt, be speaking to the CFO, the CEO, and will likely go to the board. So it's something that's not taken lightly. So I think as a taxpayer going in, it's great to have that dispute resolution process there. But of course, it's only one we would, really like to use if we had a really considered what we thought was a more correct position. And I think that underpins it for us. The other thing I think is important is it does present an opportunity for tax administrators and taxpayers to enter into and preserve business relations. So, you know, there's professional and respectful dialogue, you know, and it is generally obviously a good thing for taxpayers and administrators as it aids communication. So underlying it from the tax administrators, of course, is a commitment for a high standard, and likewise on the taxpayers. So, of course, I think there's a bit of a concern when you see some of the MAP statistics where there is a no agreement, and you'd like to think that when a taxpayer goes in, they've got a very principled, rational position that obviously they think is correct, and it's based on facts. And so a taxpayer should always stress test that before they enter into an MAP process. So it's always very easy to convince yourself you have the right position, but you should always stress test something before you go in and almost take an opposite view. And I think if you do that as a taxpayer, hopefully, you know, you've narrowed down to, instead of having a disagreement or a range of outcomes that go from here, we bring them down to here with the tax administrators. And I think that's really the end goal, that there has to be a bit of tolerance. And of course, you hope that if you've got a good professional dialogue where the facts are clear, then any disagreement should be within a narrow tolerance level. Of course, that's not always the case, but that's the ultimate goal. So a bit like my hospital analogy, Robert, prefer not to go. If I do go, I'd like to get fixed. And I think that's probably right for both tax administrators and taxpayers, you know, resource constrained. If you go to the time and effort and the cost, and they're not insignificant, it would be nice to see that we have more and more of them closed out rather than left open. But I'm happy to take any questions, Robert, and I understand there's some questions from the floor towards the end of the program.
Thank you very much, Patrick, for describing the landscape also and the expectations from a business point of view. It is true that the peer review process actually plays a key role in this area. I should say that also globally, currently, we are seeing the emergence of significant controversies that may indeed, in the end, impact the functioning of the map. If you take, for example, the cases of embedded royalties that we have now in Australia, this is a very far-reaching trend that may, you know, that is basically rooted in the desire to have more source taxation, but that will probably just trigger also disputes. Another range of disputes is the fact that, of course, the map is related to taxes on income and capital, but in some countries you can have disputes around other types of taxes, such as GSTs. So you have a lot of challenge, and with that, I would like to turn over to Permana Adi Saptura for perhaps a concluding input from an Indonesian perspective.
Okay, Mr. Robert and also Patrick, sorry, Mr. Faris Kaka, I have to go to the airport right away. So I'm sorry that I cannot attend this seminar until the end. I just want to address two issues. Thank you for input from the business community. I believe that is a very good issue that we are trying to resolve right now. We are trying to reduce our non-agreement issues, but sometimes the discussion is not discussing about the transfer pricing itself, but other issue, for example, not in the scope of the treaty. Another issue that I would like to add is regarding one question that Mr. Faris Kaka mentioned regarding the arbitrations. In my slides, actually, I have mentioned that on AP cases, we have one countries that we have arbitration actually in our treaty, which is with Mexico. But until now, we don't have any request to not only MAP itself doesn't have issue that we have with Mexico, so we don't have the discussion. But in our treaty, we have arbitration. This is I can also relate with the ICAP and also the one that you mentioned. ICAP, we already discussed this with the OECD, with Pascal last 2 years, and we discussed this with Australia and also. Right now, our domestic regulations, it is not in accordance with the agreement achieved through ICAP or through other arbitration method. So if we are moving to those directions, this is issue that we can handle without through the formal issue, or not through domestic or through the MAP or APA. This is another method that we can use and give the opportunity to taxpayer to resolve this issue. But until now, our domestic regulation do not support this position. So if we want to go to the direction, we need to change our domestic regulations first through tax law. Sorry for the have to go and then cannot follow to the end of this discussion. Thank you.
Thank you so much, Pak Mekarsari. If you may have a little bit of time for us take a pictures together in the stage, in the center of the stage, maybe Pak Iwan and Pak Didit also can be on the stage for take pictures, and also Pak Cindy. Thank you so much. Give one big applause to Pak Mekar. Thank you. Oh, okay. And also we would like to invite the team of Pak Mekarsari, Mr. Pramuji Handrajadi, to be on the stage. Okay, thank you, Pak Permana. The stage is yours. Big applause for Pak Permana. Thank you.
All right, thank you very much, TS. Thank you, Robert and Porus, for your view from the global perspective on the BEPS 14 as well as the MAPS. I think this is a very interesting discussion about MAPS. I want to give a perspective from the practitioner in which there are a lot of advantage on the MAP, but the question is why? Why not many taxpayer using MAP as a part of their dispute resolution? I think this is something that I want to discuss in the session. Yeah, I don't have many slides, and I'm trying to manage as quick as possible because I think the time is flying. All right. Next, yes. I believe I saw many friendly faces here. I think most of us is also the practitioner, the consultant, and dealing with this kind of things, which is more transfer pricing correction by the tax auditor. I think this is happening for the last few years, and especially after the PMK 172 year 2023. I think it's going to be more and more tax adjustment on transfer pricing. I believe, yeah, especially for the local and domestic transaction become one of the big issue in the PMK 172. So I believe there are more transfer pricing adjustment in the future. So most taxpayer, based on my experience, they are not using MAP as one of the dispute settlement, but most of them goes to objection and also appeal. And the problem is gonna be in the court, because I believe Nowadays, a lot of cases stuck in the court because a lot of cases go to the tax court, and then the tax court is quite overloaded, especially with the transfer pricing cases, which is, I believe you are now dealing with transfer pricing cases in the tax court in which the judges probably they have a very small knowledge on the transfer pricing. But lucky for us, actually, I believe team of Muji already visited the tax court and then do a lot of sharing session in the tax court, ya Pak Muji. Yes, I believe the team from the internal taxation already did that. I hope that in the future, more and more judges understand about the transfer pricing. But then now, why again mutual agreement procedure not as a part of something that the tax office the taxpayer wants to use? Next. Yeah, I believe Mekar already explained about this as well, that the dispute settlement under the domestic and also the cross-border. Next. Yeah, this is the advantage and the challenge. Why the taxpayer doesn't want to use the MAP as a part of the dispute settlement. Again, the advantage, I believe, Porus already mentioned earlier as well about this issue that definitely using the MAP will avoid the double taxation issue. Yeah, because there will be involving the other countries on counterpart, the other jurisdiction or country. So there will be no double taxation in terms of the MAP's result. And MAP's process is cost efficient and effective. Why cost efficient? Because the process is only single process, while using the domestic remedies, as you see that you need to go through the objection process and appeal process. And if the tax officer don't agree with the result on the tax appeal, that they will go to the Supreme Court. So it's gonna take a very long process and involving a lot of parties in the process. But while using a BAPS process, you will dealing with the Directorate of Internal Taxation. And the other advantage that MAP result may reduce the potential dispute in the future, because this one, as a result of discussion between two tax authorities, and then the DGT already agree with the decision, I believe the taxpayer, they have a pattern, they already have some certainty on the margin, for example, on the transfer pricing issue. Then in that case, the result will give some more certainty for the future dispute. And the challenge, this is something that quite interesting based on my experience discussing and promoting MAPs with the taxpayer. Number one, because the party involved in the MAPs, at least there are 4 parties: Indonesian taxpayer, and then Indonesian DGT, and then other jurisdiction tax authority, and our related party, at least 4 parties involved. In this case, we need to get the quote-unquote willingness and readiness of the counterparty position, whether they want to deal with their tax authority. That's number one. And then the other one, sometimes, and many times actually, Indonesia only a small portion compared to the global practice. So we are not really, because we are really a small portion for them, then they don't want to deal with this kind of thing, because really hassle dealing that with the tax authority in other country, while Indonesia is not a big portion from the global perspective. And it's create more administrative burden actually for the related party as well, because they need to, prepare the collecting data and then dealing with the tax authority, need to submit the documents and everything. And also they need to do the procedure of MAP with their tax authorities. So this is creating more burden for the related parties. And some of related parties, even they don't want to open their book or open their condition with their own tax authority. So leave Indonesia handling by themselves. So this is actually the challenge, three big challenges on the MAP mutual agreement procedure from the taxpayer perspective. Next, if you want to see the MAP statistic in Indonesia, I believe maybe this is not really the updated one. Yeah, this is from the DGT website actually. Porus already mentioned as well in 2022. We already concluded like 10, but then maybe and then I think Mekar already mentioned earlier, but based on the data that we have, the statistic, it shows that MAPS is not really increasing. I mean, it's a kind of stable in the certain number of application received, which is around like 10 to 20 number 20. And then next, this is the one that I mentioned earlier about the dispute settlement in tax court, in which the dispute in tax court, the number of cases actually is quite interesting, which is there is a good trend basically in the tax court to 2023, while we see in 2019 there are the new number of cases is 15,000. And then in 2023 dropped to 10,000 cases. Yeah, the one. 12,000 cases from 15,000 cases. And if we see the tax court trying to finish to make decision as soon as possible as well, if you can see there is an increasing number of the court decision, which is in 2019 we have 10,000 cases finished and then announced by the tax court, and in 2023 there are 16,000 number of cases, but still 9,000 left in the tax court. It's still a huge number of cases, and I believe in 2024 there will be also a high number of the new tax cases coming. Based on my, if I'm not mistaken, now in the tax court there are new policy just issued recently that the tax court will, or in their new policy, they're going to issue the decision only in 3 months period. I think this is a good information for us and for taxpayer as well, because this is a new policy just issued, and then hopefully they will apply this during this 2024, because they limited all the dispute only 3 months after they ended the court hearing. Next, I think the last one in conclusion, number one is MAP is definitely an option for effective dispute resolution, considering that the number of outstanding cases in the tax court is also very high. And as I mentioned earlier in the beginning, that a timely manner to finish the case in the court is also very long, 3 years up to 6 years. And if they go to the Supreme Court, there will be additional probably about 6 months after 1 year. And MAP may prevent double taxation, while the decision from tax court doesn't prevent double taxation. But then something that the taxpayer need to be considered, that taxpayer need the readiness and the willingness, the counterparty, to go through the MAP process, because I believe that's going to be a burden from the counterpart or the related party perspective. Thank you very much.
Thank you very much. I think we now have, if I'm not mistaken, a few questions that we can address during the Q&A. Maybe we may wish to display them on the screen. I received in the chat a question that we can perhaps project. Is it possible?
Yes, thank you, Robert. I have a question that's here. So I have
Okay.
I have some good news, which is that we have received so far only 2 questions. And even better news is Dr. Uttama has already answered one of them.
Okay. Sounds promising. So I don't know. I see a question that has been addressed to you. I don't know whether you wish to comment as well.
Yes, so I think let me read it and then I'll perhaps give a few thoughts of my own and then open it even for my panel members to give. So the question is referring to the explanation on BEPS Action 14. The action plan has provided tools to secure certainty, simplification, and assurance of access to MAP. From Mr. Kaka's explanation, despite the certainty tools, the reluctance for a settlement through arbitration will most likely arrive at the agreement to disagree due to various reasons, mostly due to national interest. While this is a non-technical reason, Action Plan 14 requires good faith from both competent authorities to resolve the tax dispute. I would appreciate if Mr. Kaka explores more on arbitration resolution avenue, especially the potential appointment of an expert panel to be involved in such resolution avenue. So I think when I look at the question is really, is arbitration itself a part of good faith in the treaty? And while arbitration is not really a part of the good faith, I think it signifies the lack of faith in that resolution mechanism, especially for developing countries. Those who are non-OECD members are extremely reluctant for arbitration. So let's look at what are the reasons globally touted as the reason for not having arbitration in your tax treaty. One is sovereignty. One is the capacity of the administration. And the third is the lack of faith in the forum. If we analyze all of them, I do have reservations on sovereignty being a valid argument. The reason is, when you sign a tax treaty itself, you are giving away your sovereignty. You are agreeing that you will not tax a non-resident except as provided under the treaty. Once you have given away your sovereignty to that extent, to have a forum to decide what is right is not a loss of sovereignty because you've already consented to that taxing mechanism. The second, and I think more valid issues which are there for the developing world, and India is certainly one of the countries which has strong reservations on arbitration, is the capacity and it's the forum. Now, proud to know that globally, most of the developing world over the years has produced extremely competent revenue officials, both in international knowledge of the subject and also the ability to put that forward, whether they be from the Far East, from Asia, to put forward their views in the international stage. So I think the capacity of the revenue is rapidly changing, and that is perhaps a comfort level wherein one day they will feel they have the ability to put forward their case in the arbitration forum. The third aspect is what is the forum and who are the experts. So far for the developing world, especially in treaties, whether they're investment treaties or tax treaties, the arbitration has, or the decisions have been relatively negative. So they are unsure. Asia needs to catch up. I think we need global tax professionals beyond their country specialists. at an international level. We also need global revenue officials who are comfortable at that level and who are able to put forward their case within the current rules. Now, why do I say within the current rules? Because whether we like it or not, today you have the OECD treaty, you have the OECD commentary. So when you put forward a case for arbitration, it must be within those rules, within that commentary that you have to argue. You cannot create thinking out of the box, whether it's on royalty or FTS, etc. No, this must be royalty. You have to work within the rules. And I think the ability to put that forward by global professionals, and especially Asian global professionals, will give a huge confidence to the revenue of that country to decide whether they want to go forward or not with arbitration. Eventually, it is coming in bits and pieces, as I mentioned in my presentation, with regards to certain issues on the correlation between the Pillar 1 issues on PE, etc. There is a mechanism coming into force. There is a dispute resolution mechanism even on Amount A that is coming into force. These are small starts. But the main issue of arbitration, the developing world, has justified and some perhaps slightly unjustified reservations. But hopefully that will go forward, because ultimately I think to settle tax disputes, whichever mechanism you use for the country, for the taxpayer, for the investor, is always in the ultimate interest.
Yes, thank you very much, Boris, for that input. I indeed wish to echo your comments. I think that the role of arbitration is also a significant incentive to the promotion of foreign investment, as it promotes also, it's an additional insurance of legal certainty. I do also want to mention that there are certain intermediary options which have been actually advanced in order to give expertise to those involved in a dispute, and these involves, of course, an independent panel issuing non-binding recommendations, for example. So you have a host of intermediary avenues that can find their ways within these constraints. But I wish to echo your comment that, of course, arbitration is also an incentive in the sense that it also promotes foreign investment. In that sense, is in the interest of developing countries.
Okay, maybe to add the context to Indonesia right now, we actually don't reject the arbitration proposal, but actually we lack of urgency to have arbitration because we have only one treaty that cover arbitration, which is with Mexico, and even we have no MAP cases with Mexico right now. Besides that, I want to emphasize about the no agreement MAP cases in Indonesia. You see that the number is 34. If I may give you the background is coming from the previous Ministry of Finance regulation number 49, because in the previous, if you apply MAP and you apply the into the tax court, if you want to all into the MAP, you have to withdraw all the cases in the tax court. That's what we change. We amend in the newest regulation. In the newest regulation, we make it more flexible to taxpayer to do shopping in the tax resolution. So we believe our number of no agreement in MAP will reduce significantly. That's why to add the context of what Mr. Porus have said, sovereignty, yes, expertise, yes, but for Indonesia context, we need more urgency to do regulate more detail about the arbitration, because we have the regulation, in the tax treaty, but the domestic regulation, we still do not have it.
Thank you.
Actually, that's my question. No, I mean, until now, I believe, based on my understanding, we don't have any procedures to do the arbitration. There is no tax regulation related to the arbitration. That's why probably it's very few the taxpayer use the arbitration as one of the dispute resolution. Thank you, Robert.
Thank you very much. So I think there is a question now addressed to Boris again.
Yeah, I think someone to have a question, Debbie. Okay, yeah, please, Pak Balim.
Okay. Yeah, basically my question is regarding the OECD Model Convention Article 25. Porus mentioned that, in short, that both CA will do their best endeavor to minimize or to eliminate the double taxation, right? Regardless the domestic regulation of each country. So reading that regulation, I'm quite optimistic that, okay, that both CA, there is no obstacles for taxpayer to request the MAP, given the available domestic regulation. Just to put it in context for Indonesia, my question is regarding the interaction between tax court verdict and the decision of MAP. Maybe Pak Muji, you may share your comment. Yeah. To the best of my knowledge, for Indonesia, if the tax court verdict already been released, then Indonesian CA can continue the MAP, but the decision or the conclusion of Indonesian CA cannot be deviated with the tax court verdict. Right? Then if this is the case, I believe the double taxation is still happen, because seems that the Article 25 is not apply as it is, because still there is a barrier of the domestic of the Indonesian CA due to the release of the tax court verdict. My question is, what happened in other country, or Porus, do you have any suggestion basically to solve this issue? I also want to hear from Pak Muji what effort basically prepared by Indonesian Tax Authority to solve this matter. By the way, in regard to the development of the MAP resolution, DGT to apply the BEPS Action Plan 14, I believe my observation showed that DGT already doing much better compared to last previous 5 years. Pak Toto already mentioned about DGT already revised certain regulation for MAP in order to create a certainty. I think it is a good point. But still, the main concern is the one that I mentioned, interaction with the tax court verdict. Thank you.
Thank you. I think globally it is always accepted that MAP is a available remedy in treaties over and above your domestic remedies. It can go on concurrently. Now, how it can go on concurrently is regulated by most countries. Now, for example, as I understand, once there's a decision of the tax court in Indonesia, then the MAP will no longer go on, at least qua that issue which has been settled by the MAP court. So I think the decision for all countries is, at what level of court will you decide that that court's judgment will become binding on MAP? Normally it is concurrent, and concurrent up to what level? For example, I think all of us, except even all common law countries or non-common law countries, accept that certain decisions of a court, like the Supreme Court or the House of Lords or what used to be the Privy Council, are binding on all persons in that country. Now, it cannot be that the decision of the Supreme Court perhaps can be overturned by MAP. So no country will probably go there. But with regard to the courts below the Supreme Court, at what level will you say that once that court decides MAP is ousted, is a decision for that country. I would say that there must be a domestic resolution forum which is outside the revenue, that's outside or not within the control of the revenue of that government. If that is an independent forum in the appellate procedure, say, for example, you have your tax court, then you have a high court, then you have a Supreme Court. Suppose your tax court is controlled by the Ministry of Finance, then perhaps that's not, again, as I said, I don't know, that may not be the right level to say decisions are binding on the taxpayer or on MAP. You may then want to say the decisions of the High Court, which is an independent forum outside the administration, will become binding on the taxpayer, but not the decision of the lower courts. Again, as I said, it depends on your appellate procedure. Normally, globally, it's concurrent. It is in addition to your domestic tax disputes, and you are right. It's like an ice cream for the taxpayer. If they like it, they accept it. If they don't like it, they can continue in their domestic courts. But I think it must be that a domestic court, which is independent, that should be the court, that should perhaps be the level at which the government will say, now you either choose the decision of the court and we will no longer continue with MAP because this is an independent court and it has decided against you.
Okay, maybe I want to give you background how we drafting the Ministry of Finance regulation number 172. Actually, in the best practice, in the MAP mechanism, there is something we call as pending MAP, pending MAP. So in some countries, if a taxpayer choose to wait and see for the tax court, we hold the MAP and we call it as pending MAP. We don't calculate it in statistic and etc. But we don't choose that option. We choose the option that MAP can be flexible concurrently with the domestic remedy. So to answer your question, Pak Balim, MAP, if the court decision has been released, is no longer efficient, is no longer effective because MAP, we as MAP analysts cannot propose new our own position paper, but we are binding. The court decision is binding and final for us. So MAP is only mechanism to do corresponding adjustment. So the option only we tell to our treaty partner, you either you want to accept this tax court decision or not. If not, we cannot do no longer negotiation in the MAP and we close the cases because in our law system, we cannot deviate our position from tax court decision. That's my answer, Pak Bali.
I just want to add something about to my knowledge in the BEPS 14 document, like if I'm not mistaken, assessment methodology. There's also mentioned that tax authorities, competent authorities of other jurisdiction may respect other competent authorities that is bound by court decision. So we think that it's, I believe that when the court decision is already issued, we think that we cannot move or deviate from the tax court decision. So as what you said, the MAP is no longer effective.
Thank you very much. Do we have any further questions?
No further question, Robert.
Okay, so
Okay,
I
sorry.
guess.
Huh?
Oh,
Sorry,
there.
Oh, one question in the slides. Yeah, can I read it for you? As MAP is binding only upon a taxpayer acceptance, is it reasonable to have a CAs disclose the working purpose to arrive conclusions? Given the case referred was on residential status, it may be even more complicated on initiate international tax and TP issues. where do you see this going in coming times? Sorry, I cannot see. The question is to Mr. Porus.
I think so far we've all accepted that MAP is a government-to-government process, and therefore access to those papers for various reasons is not available to taxpayers directly. You have seen the exclusions of some of the cases which have proved slightly different. For example, in Belgium that I mentioned in my slide. But mostly it's extremely difficult to get access to those papers and access to what is the position papers, because it is really a government-to-government process. But I don't see any reason why that cannot change, because in any country that's governed by the rule of law, I'm assuming that if a government does take a particular position, it can't be a different position in MAP and a different position in the courts of that country in the domestic litigation. So certainly I think, but it will be up to, again, the court has to make a balance. I think to expect the government to disclose all negotiations in MAP throughout at all points in time is perhaps wrong, even from a policy perspective, because you will then make the governments extremely reluctant to have frank discussions at MAP level. But I think ultimately there will be a balance that will be made by the court as to whether that information is relevant, and therefore it needs to be disclosed, as the UK courts have done in the case of McCabe. So I think if it is, for example, if the government does take a position that this taxpayer was not a resident, surely in the domestic courts, it can't argue to the contrary, and those reasons are relevant. But I see this balance happening. So far, we have as taxpayers, we have tested this extremely limited in the Western jurisdictions. I haven't seen it tested in the other jurisdictions, and ultimately MAP is voluntary. You can't force the government's hand. Once it's a voluntary decision, it's really, you can't say that even though it's voluntary, you must, disclose. So if they don't agree, unless it's completely unreasonable, taxpayers really have no vested right. The position papers, slightly different. It could be tested more and more as we go ahead. But again, I think the taxpayer itself will have to make the balance. Do you want the force to government to disclose what it said? Is it really going to be your advantage? Or it could be actually to your disadvantage. So it will be a decision to be carefully made by the taxpayer before he approaches that country's court.
I think that to follow up on what you said, Porus, this question was raised also on a number of locations where we had the traveling lectures, and we got interesting, leaving aside the legal discussion from a policy standpoint, we had conflicting answers. On the one hand, you had the ones that were advocating for more transparency in the MAP outcome, along the lines of the idea of developing or making available a MAP practice. But also you had those, even on the side of business, to say, well, as you say, MAP is a government-to-government discussion, often the result of a compromise. If we were to publish, to some extent, we would lose that flexibility. So from a policy standpoint, it's interesting to see that there is quite a tense discussion from both angles. Yeah. So I think that if there are no further questions, that concludes this session. I'm again deeply disappointed not to be able to join you for the cocktail, but I hope you will have a great time in Indonesia. I hope that the discussion was fruitful, that the connection between Global IFA and the branch of Indonesia was successful. And I hope also to have the pleasure not only to see you in the future in Indonesia, but also to see at least some of you in the forthcoming IFA Congress. Thank you very much.
All right, thank you very much. It was a very productive sessions. So for moderators and all panelists, please take a pictures together on the stage. I would like also invite Pak Iwan for the receiving or for giving the placard appreciation to the moderator and also the panelists. Yes, take a pictures. Pak Cindy. All right, great. So to Pak Iwan, so please give the placard to me. To the MC. All right. Now give one more time, big applause to all the panelists and moderators. All right, we will now come to the next sessions, the concluding remarks. These concluding remarks will be given by Mr. Ikhwan Sukardi, the President of IFA Indonesia and Head of Tax RSM Indonesia. The stage is yours, Pak. Please give a big applause to Pak Ikhwan.
Okay. Thank you, Angela. I think to conclude this session, first of all, I'd like to give big thanks to Porus Kakak for, I think, personally coming to Jakarta. Hope you enjoy the rest of your time in Jakarta because it's flying back to Singapore first and then to Mumbai. Also to Robert Danon, Patrick, and Pak Mekar, Pak Muji, sampaikan salam saya buat Pak Mekar and Pak Permana. Also all participants that we learned, I think one thing that I couldn't agree more from you, Porus Kakak, that in order to settle tax dispute, then what most of taxpayer needs is it's not right or wrong, but I think it is more on reasonableness, especially for TP cases dispute settlement. And I think we agree also that the MAP has been in the tax treaty provision from, I think, the first treaty was drafted. But I think if you look back for the 5 years back, I think rarely taxpayer file for MAP, but then the use of this provision has been increasingly and promisingly give more job security for most of us here. So you don't have to worry. In addition to that, you'll have, as I think we discussed, 2 pillars homework also. A lot of taxpayer face some or have big questions on this, and how are we going to face with this in coming years. So we understand for pillar 1, I think as Pak Mekar mentioned, we are still waiting for, I think, global consensus. Though I think, just for your information, Porus, we do have our provision, our domestic tax provision, then we'll implement some things like DST, but it is put pending subject to the issuance of government regulation. And the next one is the new UN model. Jadi, so we've been following the development of UN models, but then I think there will be a more interesting development in coming years, because in the past, I think UN model follows merely on OECD, copy OECD, but only some modification. But I think they may come up with some further interesting development to maybe develop their own model. So I think following our discussion, I'm doing my research on both on Indonesian treaties, so that I found out that my research that Indonesia more adopt OECD model than UN model. I think because of this, most of the treaty provision itself, it is they are both OECD and UN model. They are identical. And last point is on the what is mentioned by Patrick, that MAP is like go to the hospital basically. So we try to avoid, but if we have to, then we have to. And I think in order to avoid this situation, and then we have to keep our body in the very fit condition so that we can stay awake, we can keep healthy, and then also try our best to focus on different things. But at the end, if necessary, then we know the process, and I think it is more transparent, more I think faster. It has been proved. So we represent some clients in the MAP process, and we know exactly if it is in relation to the treaty, the transfer pricing, then the result would basically we put on hope on that. But on treaty interpretation, then normally it is on the what the provisions say to agree not to conclude any agreement. I think that's all. And again, thanks very much, and we'll update you on our next IFA event. And enjoy the rest of the evening. Thank you.
Okay, thank you so much, Pak Iwan. So in addition, we would like to inform you that the musola is actually on the right corner of this room. So you can go out and then go to the site. And finally, we are now came to the cocktail and dinner. We hope that you can join us until the very end of this event. The dinner will be on my live set, my left side. And then for all of you who join us in person, we do hope you do enjoy our hospitality and also refreshing from your busy schedules. Distinguished guests, we would like to express and thank you for all your support. We would like to also thank you, the lecturers, the moderator, panelists, committee, and also the distinguished participants who joined us on this event today. So I'm Angela Argusumaningtyas. I'm the head of tax of Citibank Indonesia. On behalf of the host, it is really honored to extending appreciations and hoping you all have a great day, healthy and success. Ladies and gentlemen, please give us a line of applause for all of us in this room.
Yeah, yes, my team. Okay. Yeah, Pak. Yeah.